Hello friends, welcome back to our Bnss series. Today we are covering the chapter 31 of Bhartiya Nagrik Suraksha Sanhita 2023. This chapter related with appeals. This chapter is very much important. This chapter includes section 413 to 435. This chapter importance because this chapter explains us when appeals are allowed, when appeals are barred, who can go for appeal, and what powers appellate court have. So let's go step by step, section by section. Chapter 31 Appeals. Section 413. Section 413 sets the general rule for appeal. No appeal lies from any criminal court judgment unless the law specifically allows it. But there is an important exception. The victim has the right to appeal against the acquittal, conviction for a lesser offense, or inadequate compensation. Section 414 allows an appeal against order requiring a person to give security for peace or good behavior on where a surety has been rejected. Section 415. Section 415 explains which court you can apply to. If convicted by the High Court in original jurisdiction, appeal goes to the Supreme Court. If convicted by the Sessions Court or given more than 7 years imprisonment, appeal goes to the High Court. In other cases, appeal lies to the Sessions Court. So, section 415 explains us where appeal we can apply for appeal and which court have power for appeal. Section 416 says if the accused pleaded guilty and was convicted on that plea, generally no appeal is allowed. Exception appeal is possible only about the extent or legality of the sentence. Section 417 bars appeal in petty cases, for example very small punishment or small fines, to avoid burdening higher courts. Section 418-419. Section 418 gives the state or central government power to appeal for enhancement of the sentence if they find it too lenient. Section 419 provides for appeal against acquittal by the district magistrate to Sessions Court or by the state or central government to the High Court with the court's permission. Section 420. Section 420 says if the High Court on appeal reverse an acquittal and convict a person with death, life imprisonment or 10 years or more, that person can appeal to the Supreme Court. Section 421. In joint trial, if one accused has a right to appeal, all co-accused convicted in the trial also get the right to appeal. Section 422. Appeals to Sessions Court the heard by the Session Judge or Additional Session Judge. In some smaller cases, the Chief Judicial Magistrate can also hear the appeal. Section 423-424. Section 423 says every appeal must be a written petition, normally with a copy of the judgment. Section 424, if the appellant is in jail, he can give the petition to the jail officer who forward into the appellate court. Section 425 says the appellate court can dismiss an appeal summarily if there is no ground, but only after giving the appellate or lawyer a chance to be heard. Section 426. If the appeal is admitted, notice are sent to the accused, prosecution and complainant, and the record of the trial is called for. Section 427. On hearing, the appellate court has wide powers. It may acquit, convict, order retrial, reduce or even enhance the sentence. But enhancement requires giving the accused a fair chance to respond. Section 428. Rules for appellate judgment are similar to trial judgments. The accused needed not be present unless the court directs. Section 429. When the High Court decides an appeal, it certifies the decision to the lower court, which must update the record accordingly. Section 430. Pending appeal, the appellate court may suspend execution of the sentence and release the person on bail. Special safeguards apply if the sentence is death, life imprisonment, or 10 years or more. Section 431. In an appeal from acquittal, the High Court may issue a warrant to arrest the accused and keep him in custody or grant bail during the appeal. Section 432. The appellate court may order additional evidence if needed for justice, but reason must be recorded. Section 433. If High Court judge differ in opinion on an appeal, the case goes to another judge or sometimes a larger bench for final decision. Section 434. Appellate judgments are generally final except in cases where further appeal is specifically provided by law. Section 435. Appeals usually abate if the appellant dies. Exception: if the appeal is against a conviction and sentence of death or imprisonment, a close relative like parent, spouse, child, brother or sister can apply within 30 days to continue the appeal. If allowed, the appeal does not abate. So friend, this was the chapter 31 of the Bhartiya Nagrik Suraksha Sanhita, which related to appeals. This chapter explains us all about the appeal. If you found this breakdown useful, then share, like and subscribe this channel Kayda Vato. We will meet soon with next chapter. Till then, bye. Take care. Jai Hind. Stay connected with Kayda Vato. Stay informed. Stay strong.